Then there is the issue of tax litigation. And just yesterday, the IRS finally provided some guidance to the investors in Madoff regarding the tax treatment which would be available. This is a complex issue, but essentially you're dealing with the ability to declare this as a theft loss for tax purposes, carry it back for 5 years, and for a lot of people, this is going to be the most significant source of recovery. Unfortunately, a lot of the investment came through 401ks and IRAs and other tax-exempt vehicles, and for that it doesn't appear this will offer much. And finally, within the area of direct investments, there are suits that the receiver might bring, which are clawback claims, where individuals who actually pulled out money from Madoff, some of those may consider themselves the lucky ones, will find themselves on the back end of a lawsuit themselves. It says that that is a fraudulent transfer of money from a Ponzi scheme. These are difficult claims for the defendants because if it's coming out of a Ponzi scheme, the payment is viewed as an actual part of the fraudulent operation. Now, the receiver has said, however, that he only intends to pursue these claims against individuals that have actually made a profit, that have withdrawn more money than they put in. And at least his initial focus is on distributions that occurred within 90 days of December 11th, although I think it's likely that they'll go back further. The law allows them to go back further, and that this will be, not immediately, it'll probably be a year or so before this starts, but a substantial source of litigation that is occurring. The other side of the equation are the indirect investors, people who invested in a hedge fund or other fund that in turn invested into Bernard Madoff. And I'd like to just talk briefly about the different types of those suits and then deal with a few of them in a little bit more detail. There are suits against feeder funds, which are in these investment vehicles, and there the defendants are the investment manager, the placement company, marketing companies. A lot of these had offshore companies related to either other offshore companies or an onshore business, and the principals of those companies. There are third-party defendants, which include the custodians. For example, Citco Bank. Citco Bank was probably the largest custodian for hedge funds in the world. They provided lots of back office services, and they have been sued in many cases for failing to use proper care in making sure these securities actually existed. Or in supervising Bernard Madoff, who was set up as a sub-custodian for these assets. There are also claims against fund administrators. These are the people who were supposedly going to calculate how much were the assets worth in the fund every month and to send out notices to investors. They received a share of the fees based on the inflated asset values in these funds. So at least there's going to be a serious issue about them returning those funds. In fact, I think that's more than a serious issue. I don't see much of a defense to people who took out a fee based on an inflated value due to the fraud. But then there will be issues that their negligence in reporting an inflated asset value will lead to them being responsible for losses beyond the fees that were paid. There will be claims against fund auditors with issues about whether or not you can satisfy the requirements for privity and linking for third-party claims against auditors. And there will be claims against what we call leverage providers. These are banks that would go in there and say, you want to invest in Madoff? Well, I have a better idea. Why don't you invest in our fund, which will give you leverage, and you can have 3 times the appreciation. That happened, for instance, J.P. Morgan had a program like that, which until the fall of 2008 had a lot of investors in it. In the fall of 2008, J.P. Morgan closed down that program, withdrew about $250 million. There's still a lot of people who have claims which are guaranteed by J.P. Morgan under those notes, and then there's people who are simply fully exposed to Madoff. There's yet another level of potential litigation from indirect investors, and those are suits against fund of funds. So now we're talking about people who invested in Madoff 2 steps removed. They invested in a fund of funds. Part of the fund of funds invested in a feeder fund into Madoff. Here, you have claims about fund managers, again, not protecting that part of their investment against being put into a Ponzi scheme. This type of litigation, I think, is fundamentally more difficult than the direct feeder fund cases, because here you dealt with a lot of funds that were well diversified, and I think arguably the obligations of due diligence were a lot different than funds that put all of their money, or a great percentage of their money, directly into Madoff. There are likely to be shareholder claims for companies that invested corporate assets into Madoff. While most of the investors into Madoff's scheme were wealthy individuals, there are insurance companies, there are banks, there are a variety of public companies that got swept up in the scheme. Their shareholders are obviously not going to be too thrilled about that situation, and suits regarding those, perhaps derivative suits, will be coming down the pike.